of Minnesota. This is a White case, and my own perspective, and it's only my view, but I was very disturbed by the 5-4 decision. It's my understanding that Minnesota and a number of other states had passed legislation regulating judicial elections, that a candidate for the court could not take a specific position on issues, and the court ruled that that violated the First Amendment's free speech. Would you speak to that issue?
Yes, the actual issue that was before the Supreme Court was in relation to what was called the announce clause in a rule in Minnesota, widely replicated among many states, and Idaho has had such a rule, that a candidate could not announce a general position upon an issue that was later going to come before that judge if the judge was successfully elected. And by a 5-4 decision, you're quite right, the Supreme Court said that the First Amendment trumps the issue of impartiality in that regard, and many of us think that impartiality is as much a part of the Constitution as the First Amendment, and so it was a decision with which we disagree. But there is a little bit of a silver lining. The Supreme Court did not go so far as to say that it would be offensive to the First Amendment to preclude a candidate from making a specific pledge or promise about the outcome of a specific issue in a specific case. That's still to be decided. That may be another case. Some federal courts think the Supreme Court said that's trumped also by the First Amendment, but the Supreme Court has not yet said so. If the Supreme Court were to say so, it would be a very dark shadow across that part of the Constitution which relates to impartiality. There is, however, another safety valve, and we've adverted to it here in our discussions, and that is that a judge has a duty to recuse himself, that is, to step out of a case, he or she, if his or her impartiality might reasonably be questioned. And so even if you cannot censor, that is, stop communication of particular views by candidates, you still can expect them to step aside if that particular issue comes before the court. Now, some folks say, well, then that defeats the whole purpose of the election. They want to get elected based upon pledges and promises. But if that were the case, then it really reveals what the danger is to the Constitution of a broad interpretation of Minnesota versus White.
I think there might be another check here, too, and that is if a candidate got too willing to take stand on many issues to get elected, not only is that judge putting himself or herself in a position that many attorneys may ask for that person, that judge, to be excused from the particular case, and also the media could play upon this and say, too, this judge has taken these and these positions, and now he's going to try to decide this case. So there is from the public and the media that opportunity, too. The judge could be putting itself, Justice Trout, would you not think, in a very difficult position for the future?
I would hope that there would be people, media, citizens, and others who would take the judge to task for that type of thing. Yes, precisely.
I guess it's Janelle Burke's turn.
My question is for Linda Trout. Justice Trout, you are very familiar with the roles of the various courts, and I'm not sure that all viewers understand the differences between the roles of, say, the trial court, the appellate court, and so forth. Our appellate judges are very local for the most part, and yet our appellate judges sit over a state generally, or a region, a larger region in a state, in the case of Washington. But give us some understanding of what those various roles are and how judges follow the rule of law depending on the level at which they're operating.
In Idaho, we have 2 trial court levels and 2 appellate court levels. The 2 trial courts are magistrate and district court. Magistrate is what we call a court of limited jurisdiction. It's limited in terms of the types of cases that the judge can handle, and actually it's probably the court that most people are familiar with because they do traffic court and custody cases and probates and small claims and things like that. The magistrates are very fact-driven in terms of analyzing the cases that the parties have before them and, of course, following the rule of law and rendering a decision in those parties' case. The district court, then, is a court of general jurisdiction. Again, a trial court, so they're doing jury trials and court trials and hearing witness testimony and depositions and all of those kinds of things. But district judges have the ability to handle the serious felony criminal cases and lawsuits that involve more than $10,000. So it's the more serious, typically, types of cases, although I probably shouldn't say serious when you consider that magistrates are doing custody cases, which are very serious to the parties involved. Then at the appellate level, there's the Court of Appeals and the Supreme Court, and those are courts that do not do trials. They don't hear from witnesses. They are removed from what the public typically thinks of, I think, of what judges do. Appellate judges sit and listen to what attorneys have to say in terms of argument and are simply there to decide whether or not an error was committed in a trial judge or a trial court or before a state agency. So it's really a court of review that is simply analyzing what went on below. And interestingly, there are different types of elections that are dependent upon the type of position you hold, interestingly. Magistrate judges are elected only within the county within which they sit. District judges are elected within the district in which they sit. And appellate judges, both Court of Appeals and Supreme Court, are statewide positions. And so when we run for election, we're required to go out statewide, and hopefully the voters can get to know us on a statewide basis before casting their ballot.
You know, your question, if I may build on that for a moment, really is very helpful in this respect. It helps us identify what we really mean by impartiality, because it is the role of the trial judges, magistrates and district judges, to find the facts when there's conflicting evidence. And we expect them to do so with impartiality, not to shade the facts one way or the other. That's very important. And the appellate courts don't refine the facts, but they look at the law and determine whether the law has been correctly stated and has been applied correctly to those facts. So we want those judges to be impartial with respect to their interpretation of the law and not bring their own legislative type agenda to it. So I think your question really helps us understand what we mean by impartiality. We mean fact impartiality and we mean law impartiality.
Thank you. And I also want to ask Dean Burnett about the chilling effect that it can have on candidacy if you have contested elections and elections in which great amounts of money have to be raised, or there are advertising campaigns or name slogans or any of those kinds of things.
Well, the types of people who make the best judges ordinarily are reflective, thoughtful, conciliatory in their attitudes, trying to keep an open mind with respect to more than one position, and to thrust those people into fundraising and going out and asking for money based upon specific positions, or to engage in acrimonious name-calling or negative types of campaigning. I suppose everybody who enters public life has to expect some of that, but it doesn't make necessarily for very good judges. And the kind of person who, as a law student and later as a lawyer, might be thinking about the judiciary as a career, somebody who's idealistic, somebody who really wants to improve the administration of justice, is not going to be attracted, but is instead going to be forced to have second thoughts about whether to make the judiciary a career, if the way in which to pursue that career is to always be on the campaign trail between elections and to be taking positions and then going before the litigants later and saying, well, I may have said one thing in the campaign, but now I'm going to try to be impartial. That's a very difficult position to put people in.
And I want just to give you both an opportunity to comment on the fact that judges don't make decisions looking over their shoulder about the next election.
Well, I do believe that the judges make an honest effort in that regard, even those who are elected and in those in which there is money expended. More so maybe than the public realizes. But the issue here is not what the individual judge does. The issue is how much confidence does the public have in the impartiality of the judiciary. Many people say that their common sense tells them that decisions and power follow the money. And they see it happening in the other branches of government, and for them then to suspend their disbelief in that and to say, I think a judge can be impartial even if a lot of money has been invested in the campaign and the judge has been out there announcing positions on issues, is just a little too much, and I worry about the lack of confidence in the judiciary over time, and that's what we mean about the shadow across the Constitution.
Erna Reinhardt.
I gotta take us off on a little lighter note for a second. Share with us, both of you, what you like best about your job. Justice Trout.
Well, I feel like I have been honored and privileged over the last 25 years to be a judge. The opportunity as a trial judge to get to resolve conflict, to sit and listen to two sides and then reach a decision that hopefully is the right one for the parties. That is just a wonderful gift to be able to do that and to get paid to do that. And in the last 15 years, when I've been on the Supreme Court, again, the opportunity to hear cases, but to decide them on a statewide basis, not involving just the parties before me, but render decisions that will impact everybody in the state of Idaho. It's an awesome power, awesome ability, and it's been wonderful. It's challenging and interesting. Every day is different. Every legal issue is different, and I just feel very privileged to have had that opportunity.
Dean Burnett, we have 30 seconds.
Well, all of us are teachers.
Judges, when they write opinions and when they announce their rulings from the bench, if they explain them honestly, are teachers. Journalists in their highest calling are teachers. Law professors, of course, are teachers. So teaching is really the energizing element in all of these careers. In addition, helping shape good ethical values for our practitioners. At the University of Idaho College of Law, we have a pro bono program for every student, not just those who choose it, but every one. That's an indication of what you can do to improve the level of ethics, and society can take pride in its legal profession as a result of what the college is doing.
Thank you both so much, Justice Linda Koppel-Trout and Dean Don Burnett of the University of Idaho Law School. It's been wonderful having you 2 weeks to talk about shadow over the Constitution, the attack on judicial impartiality. And may I say to Justice Trout, good luck in your next endeavor, your next phase of your life. Ladies and gentlemen, we've enjoyed this program so much, and we know you have too, and we invite you to be with us again next week at the same time. We'll do another subject. Until then, please have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running in-house college production on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us at this same time next week for another edition of Public Forum on this public television station.